in our last content, we talked about void marriage, in which we stated that a marriage can be invalid from onset. However, this content will be explaining instances where a marriage can be voidable. So what do we mean by a voidable marriage? A voidable marriage is one which will be recognized as being valid in all aspects until the competent court decrees its annulment. In a voidable marriage, it is only the court that can declare that it is void and hence gives a verdict of dissolution. In a very simple term now, it is obvious that there is something wrong with the marriage, but it is only the court that can pronounce a dissolution. The husband and the wife on their own cannot just go their separate ways and assume that their marriage is no longer existing. They will have to go through the court. One of the parties must approach the court for it to be dissolved, and this the court will do, after considering all the facts and the principle, guiding this particular type of marriage. So let's consider instances where a party in a marriage can approach the court to dissolve his or her marriage on the ground that it is voidable. Number one, incapacity to consummate the marriage. In a situation whereby a party in a marriage is unable to consummate his or her marriage, that is, unable to have sex with the other party right from the day of the celebration of the marriage, the provision of section 5 sub 1 sub a of the Matrimonial Causes Act makes such marriage voidable, and the other party can approach the court to nullify such marriage. Then the second one, the provision of the Matrimonial Causes Act, specifically section 5 subsection 1 sub b, explains that if at the time of the celebration of the marriage, one of the parties to the marriage is of unsound mind and it is unknown to the other party, then that other party can approach the court for dissolution, and it will be granted by the court on the ground that it is voidable, but it must be unknown to the party as at the time they are celebrating their marriage. So the next one is that a marriage will be voidable where at the time of its celebration, one of the parties to the marriage was suffering from a venerable disease in a communicable form, and the other party can file for dissolution of the marriage. But he or she must be able to prove that the other party suffering from this disease was actually suffering from the disease at the time the marriage was celebrated. We make reference to section 5(1)(c) of the Matrimonial Causes Act. Then lastly, by the provisions of section 5 subsection 1 sub d of the Matrimonial Causes Act, a marriage will also be voided where at the time of the celebration of the marriage, unknown to the husband, that the wife was already pregnant for another person other than him. In this instance, the husband can approach the court to dissolve such marriage. Now, it is important to state that in all these circumstances, a party filing for annulment of dissolution in court must not have been aware of all these four conditions at the particular time when he or she was celebrating a marriage with the other party. These are the conditions where a marriage can be said to be voidable and consequently dissolved by the court of law. Now, stay online for our next content where we will be considering how you can protect your interest in a joint property acquired with your spouse. Information is all you need. Stay updated.